Good evening and welcome to Idea to IPO. I'm Jason Putnam Gordon. I'm an attorney with Polsinelli, LLP here in San Francisco, California. Tonight, I'm honored to host this event. Usually, Rob Lau is the organizer of Idea to IPO. He usually hosts, but today he's got a commitment, so I'm going to fill in. I've been working with Idea to IPO on and off since about 2013. They are the largest event organization with regard to startups in the Bay Area, or certainly among the largest. And they have more events than probably any other meetup organization, bar none, as Rob Lau would say. With that in mind, tonight we're going to talk about how to relocate your startup to Silicon Valley. A couple notes before we get going. Again, my name is Jason Putnam Gordon. I'm an attorney with Polsinelli, excuse me, LLP. I'm based in San Francisco, California. My area of practice is corporate and securities work. I work primarily with startups and venture capital firms on the corporate aspect. There are many other aspects which we'll touch on some of those tonight. Now, in line with that, I think let me tell you just how tonight's presentation is going to run. So what we're going to do is we're going to spend about the first hour or so of me talking. In that time, I'll pause to take any questions from any audience members. And I'd like to make this interactive. Now, this is my first time doing this particular presentation. I've given a number of presentations. I speak about this topic all the time, but this is my first one doing it with Idea to IPO. So I'm looking forward to sharing it with you and also getting your feedback. So one of the things that I always start with is that today's discussion is about general information. It's not about legal advice. So we'll be talking about rules, we'll talk about exceptions to the rules, and we'll talk about exceptions to the exceptions. And some of those things may apply to your particular situation, others may not. And as we talk about that, I don't want you to think that anything that we talk about, even if you've asked me a question and conveyed some facts, should be taken as advice. The purpose of tonight is to educate you on the issues surrounding relocations of startups to the San Francisco Bay Area, to Silicon Valley. And, there's a lot to unpack in any legal matter, and tonight we're not going to be able to get into it. Similarly, tonight's conversation is going to be recorded. So please don't share any confidential information. Please also understand that if you say something, it's going to be recorded. Now, if you have questions, the best way to answer them is not to use the chat function. It's to use the Q&A function. And that'll pop up. That'll make it easier for me to see. So I'll first give you just a little bit more background on myself. Then we'll walk into sort of like the big picture of what we're doing and why we're doing it and what the purpose of all this is. We'll talk about corporate structure. We'll talk about tax issues. We'll talk about intellectual property issues. We'll talk about intercompany agreements. We'll talk about immigration. We'll talk about employment laws, and then we'll hit some traps and other pitfalls for the unwary. Let me talk about who will gain value by watching this webinar. So I think if you're outside of the United States and you're interested in relocating your startup to the US, this is going to be helpful. Now, it doesn't necessarily need to be a startup because a lot of these topics will apply to any other company, right? Tax issues, intellectual property issues, the immigration is going to apply. But I think it's going to be most targeted to startups. And it's going to be most targeted to startups that already have a business or some sort of as a going concern, right? They've already got a product to market, maybe in their local market, and they're going to come over here because access to a bigger market, potentially even the ability to raise funds over here, since we have one of the largest venture capital communities in the world. So that's going to be sort of the underlying theme and who this is sort of geared towards. But I think there'll be a lot of value for other individuals, other entrepreneurs who are outside of the US and are looking to move their businesses over, even if they're not sort of venture focused or startup related. So just to provide a little bit more background information, again, I'm with Polsinelli, LLP, and I'm based in San Francisco, California. My firm has got close to 900 attorneys in 20 different offices across the US. I work with startups, also known as emerging growth companies, and venture capitalists as they deploy their capital. I've been a lawyer since 2005, and I love working with entrepreneurs. I sort of fancy myself as one too. Before I joined this firm, I ran my own shop for 5 or 6 years. And so that kind of, I got the bug, and it's great to to be a part of it and to work in this ecosystem. So with that in mind, we've got a slightly smaller audience tonight, but I still like to poll folks to kind of find out who is here and what their background is, and I can tailor some of our conversation to that. So what I'd like is I'm going to ask a couple of questions, and then if you could just raise your hand to see who this applies to. So who here is in a startup? All right, so fantastic. And I'll lower the hands, and then who's a founder in a startup? All right, and what we'll do is, let me ask, for those who are in a startup, is their startup, are you interested in moving here to the US? All right, super duper. Well, I think you'll find a lot of value in this conversation. Since it's a small group, if you've got questions, please use the Q&A function. I'm happy to try and answer them as we're moving through the content. And then, after I speak for about an hour, we'll have some additional time for Q&A at the end. So let's sort of talk big picture. What's going on in this ecosystem, kind of who are the players and what's getting done. So the way I like to sort of envision things is that the business is this small set of buildings here in the middle of the screen here. And you put inputs in there, and that's investment, that's capital. You put intangible assets in there. Those are the ideas. And then you've got technicians and other folks, service providers who build out the company. And if you look on the right-hand side of the screen, we sort of start talking about the startup financing cycle, right? So initially start and there's no cash. It might just be a person or two people or three people with an idea on a whiteboard. You get some seed funding, build out the initial prototypes, put the initial team together, and maybe kind of at that point you start beta testing it. Maybe you start charging some of your users or some of your customers, start generating a little bit of revenue. And as the company begins to grow, you are able to raise these financings, able to raise financing at these levels, right? We've got the first, which is also known typically as either the A or the Series seed round these days, and the second and the third. And then eventually, you'll either, if you're successful, you'll either have an IPO or you'll exit via a merger or an acquisition. That's kind of it in a nutshell. So you put those inputs in and the company starts to grow and increase in value over size. And I think one of the main jobs of lawyers are to make sure that you get all the right documentation in place so that when you're putting in those inputs, they're actually getting tied into the company and actually making it larger, making it more valuable. Now, tonight's presentation, we're going to talk on a whole host of things, which I just shared with you. The sort of interesting thing, and a little bit different from most of the presentations that I do, is that I'm going to talk about a lot of areas. Primarily, I'm going to talk about areas that are outside of my specific wheelhouse. Okay, my specific wheelhouse is the corporate structuring, the financing. But what I do in these situations when startups and other emerging growth companies and other companies are coming to the United States is that I frequently serve as the control tower, if you will, and direct traffic in the planes to handle all these issues. And so to that extent, I will be speaking about the issues that I see day in and day out. The service providers, that is the attorney specialists who come in and handle those particular issues, and what are the things that are sort of the flags that raise those issues. So on the corporate structuring side, really we're kind of trying to balance a whole host of several factors, which include business reasons, okay? Sort of a very common one is that, an entity wants to, there's a foreign corporation that is an international company, it's outside the United States, it wants to come here, wants to do business here. The US market being what it is, many times their customers only want to do business with a company that is incorporated here in the United States. There are some reasons for that. There's some optics reasons. There are some enforcement reasons in terms of being able to make sure that we can readily access the courts here in the US. We understand what that law is. So that, coupled with tax issues, potentially the fundraising, as we mentioned before, sometimes entrepreneurs want to come to the United States, build their company here because of access to capital. intellectual property concerns, that is, where is it's going to be located, whether or not it'll be defensible, and also, how the goods and services are going to be flowing back and forth between the companies. And we'll talk about that a little bit later. But those are some of the things that drive it. And in there, it doesn't matter if I'm incorporating a domestic company or a domestic entity, that is one that is here in the US, or I'm helping an international company come here to the United States. I always sort of think about 5 or 6 key structural reasons, okay? There's 5 or 6 key structural things. Those are liability exposure. Those are tax issues. Those are management structure, whether or not employees are going to be rewarded with equity. What is the capital raising and efforts? And then we often think about exit strategy as well, sort of like the 6th bonus one, if you will. Most of the time, if we're talking about a company that is or intends to be venture-backed, we're going to end up with a Delaware C Corp. And there's sort of a whole host of reasons for that which include that's usually basically what the investors want to see. So the money drives the question, and money drives the decision out of that sort of 5 or 6 factor test that I was speaking to you about. Now, when we're moving through that analysis, we don't always settle on a Delaware C Corp. Sometimes we find actually a company is not going to really pursue venture capital financing, right? They don't really need to raise $100 million over, 5 or 6 years, in which case we get the right sort of structure set up. So, if you're out there and, you hear me say Delaware C Corp is the way to go for this, that may or may not be true for your case. Kind of going back to our first caveat. What we're talking about today is general information, how it usually evolves and how it usually works, not necessarily the right answer for you and your circumstance. It's something that we or your counsel would take a look at and make sure it's correct. Now, as I said, usually what comes out of that are, the result of having a Delaware C Corp. And I say that because, look, you don't technically need to have a US entity to do business here in the United States. We'll end up talking about this a little bit more, but the reality of it is you could register your international company here and you could do business here. The problems are not problems, but what usually sort of drives these types of things are some tax issues, those customer issues, which we were talking about, all the things sort of above. Some of the other, and we can talk about some common pitfalls or mistakes later, but, some of the other common issues that we see is that, sometimes someone will think, oh, well, founder A and B are the owners of an entity in, let's just say the UK. And what they want to do is they want to bring that company over to the US. And so what they do is those 2 founders then found a company in the US, same name. You can end up with some problems there, especially as the company grows. And we'll talk about those and we'll talk about the solution to that. So it's kind of a common mistake to sort of see 2 parallel entities set up. And there are some circumstances where that could work, but it also presents some issues down the road. Now, let me also just sort of touch on, we're talking about setting up a Delaware C Corp. I mean, kind of from there's all the basic emerging growth company stuff that you got to have done, okay? That is sort of the inside egg, if you will, or inside of the onion. I think that's maybe a better analogy. And then outside, you've got this layer of all these other issues that we're going to talk about. But let me just briefly touch on some of that all real core emerging growth company stuff that you got to have, right? Like, so always, there's got to be connections between the employees or the founders and the company, and they got to tie into the company the capital structure, right? Who owns shares? What are the vesting structure associated with that? Got to tie in the IP assignment agreements, confidential information, confidentiality provisions, obligations requiring that confidential information remain as such. And we'll talk about some more of this as the evening goes on. But again, that's the sort of core of the onion, and then you gotta layer the stuff on top. Now, if a business is interested in relocating to the US and raising capital here, frequently we will end up having the US company be the parent company, okay? Because what the investors are going to want to see and what they're going to want to do is they're going to want to invest in the parent company. And they're going to want to have all of the IP flowing up into that parent. And we'll talk about the mechanics of how to do that. But that's what we're going to see. And that's what we'll focus on tonight. But, you know, there could also be other structures or other situations where, for example, you retain the parent or holding company offshore. Okay. Maybe there's assets or IP located in a low tax jurisdiction. You know, everything was formed and created out there. And so it's appropriate to keep it outside of the United States, you know, for tax optimization purposes. You know, that's another thing that we will see from time to time. I'm not going to be quite as focused on that. Again, you know, my core area is just corporate structure and financing. You know, any one of these topics that we talk about today, you could spend all day sort of unpacking a bunch of this. So, you know, again, this is sort of like, this is a discussion of how to think about relocating to the US, give you understanding of what the issues are and how those get handled. So some of the common tax issues, and again, I'm not a tax specialist, so what we always do is we always bring one of our tax specialists on board, or if there's a sophisticated CPA firm, we'll work with them, so long as they're up to speed on these international issues. But you know, some of the common things that come up are making sure that, especially if you've got a pre-existing company with assets that are valuable, is making sure as you're structuring, you're going to not result in a taxable event either for any of the parents or for any of the founders. Okay, so usually, you know, you're going to be targeting Internal Revenue Code 351, which will allow you to transfer property to cash in exchange for ownership in the new company. You know, but provided that the new owner, you know, the owners still maintain control. And so there are some pitfalls that sometimes come up there, because if you're going to be introducing a bunch of new owners, you may, you know, break the 80% threshold. And so just thinking about that is important. Usually this is sort of driven because if there is a foreign corporation that, or an international company that is out there, they don't necessarily want to subject themselves to US tax, and they also don't necessarily want to subject their employees or other service providers there. Now, that being said, you can't escape all of this, okay? The purpose of having an entity is so that all the tax gets, well, not the only purpose, but one of the purposes is make sure that all of the, so you get a firewall, right? And the folks who should be paying tax are going to get taxed. The folks who shouldn't are not going to be taxed. Now, if you've got employees over here and they're doing work, or you've got officers over here, those folks are going to be subject to US tax, and that's appropriate. But you want to go in there with both eyes open. It's a sophisticated issue. There's frequently involves treaty analysis between the countries to figure out what that burden is. And of course, also some timing tests in terms of how much time the individual is here, what kind of work they're doing. Those things all go into it. So we get the tax folks involved there. You know, the other thing, I'm going to jump down to the later bullet point in terms of special filing issues. Whenever you've got international work and you've got an entity that is either owned by foreign investors, or it's got relationships, or it's got accounts and other assets abroad, that typically will result in some special filing issues and special filings that have to get done with the IRS. I am by no means an expert of that, but certainly as you want to make sure that if you're looking for an accountant or tax lawyer or someone to help you with that, they're up to speed on it, because that is definitely a gotcha that can bite you with some significant penalties, you know, $10,000 per violation plus. And it doesn't even need to be done, the violation doesn't even need to be done with any ill will or intent. It just is what it is. Now, transfer pricing is sort of, and we'll talk about sort of the flow of services back and forth, but transfer pricing is another issue that will frequently come up. Now, that is when you've got two different entities and one is providing goods or services for the other. So let me try and make it like a little bit more concrete. If, for example, you've got a group of engineers, you know, let's say you've got US parents here, there are engineers here, they're doing development work. but there's also development work going on in the UK, and there's also a lot of sales going on in the UK, right? Like, now I think the UK has a tax treaty, so please, like, don't take this as specific advice, but the sort of concept is that you could theoretically avoid paying tax, improperly avoid paying tax by artificially charging for the services of the engineers in that foreign company, right? Because in which case you get a deduction for that, and the net is that you don't pay enough tax either in the UK or the US. You can kind of make this flow through either way. And so transfer pricing is the concept of basically making sure that you've got documentation and you've got that whatever goods and services as they're flowing back and forth, whether it is sort of engineering services or sales services or it's the IP, all that is moving back and forth at fair market value, so that you can accurately calculate in each, so you're not avoiding tax in either of those jurisdictions. It's an extraordinarily complicated subject that is, aside from the basic concept being on my radar, there are specialists. I mean, that is a sub specialty. Now, usually sort of early on, this doesn't necessarily really rear its ugly head because, in the life cycle of startups, there are not a lot of revenue to be had, but it's certainly a concept that you need to think about early. And, later in the life cycle of the company, there can be extremely in-depth and also expensive transfer pricing reviews and surveys that are done by accounting firms and other stuff. That's just not going to happen super early on, but the concept, you need to be thinking about this early, so you don't cross that threshold and end up in the wrong place. So maybe I'll pause there and see if anyone has any questions. And again, I'd encourage you to use the Q&A. Okay, we'll continue. So I'm going to first start just with a very high overview of what the types of IP intellectual property that are here in the United States. And then let's talk about kind of this issue of IP flowing back and forth. And then let's talk a little bit about branding. So for companies that form outside the United States, your intellectual property laws may or may not track what we have here. We've got patents, which are, basically monopoly rights for a period of time on either designs or processes, so that you can, either specifically use an invention or process and exclude others from using that. We've got trademarks, which is really about branding. It's about ultimately consumer protection. That is making sure that people are buying goods produced by the companies that they think they're being produced by. We've got copyrights, which protect other creativity, in terms of expression. And we've got trade secrets, which is sort of a catch-all bag for information that is kept confidential and that has economic value. So that's sort of the 4 buckets of intellectual property. I'm not an IP lawyer, so we again will frequently consult with IP lawyers, especially as we're doing licensing and other things, and we'll talk about that in a moment. But the concepts are, sort of those are your buckets of rights. IP is one of the most valuable things for emerging growth companies. So making sure your IP is locked down and is locked down across the jurisdictions is important, right? Because it's those rights to exclude that allow you to, or one of the things that allow you to, build that moat and build a defensible business behind it, a profitable business behind it. Now, touching on what we said earlier, if you're going to be raising venture capital, what's going to happen is that your investors are going to want to make sure that all of the IP is flowing into the entity that they are investing in, okay? Because otherwise, that company doesn't have the right to exclude others from doing what it is that makes that company valuable, and therefore that company is not valuable. So what you're going to want to do is you're going to see all the IP flowing up to the parent, and then usually appropriate licenses flowing back down to all the subsidiaries and all the other affiliates who need them. So in that sense, what you can do is you can think about making sure that all the IP is getting signed up. And then, if you've got a subsidiary, just not to pick on the UK, but let's just say like the UK, and that's doing sales, right? And let's say it's a distributor, right? So, or it's just basically acting as a sales agent, and the contract is actually still with the parent. Well, theoretically, you'd still want to have a license to the marks and the other things that the parent has. And you'd either want those marks in the UK, like registered there, going to the parent, or there could be some arrangement between the sub and the UK, the sub and the parent company. So the UK company like has it, but in reality, it's really the parent that controls it and has it. So that's sort of one aspect kind of on the branding. It's a little bit different, can be a little bit more complicated if you've got development teams and sales teams and other things going on. So just kind of taking the development team aspect. If you got development going on in the US and you got development going on in a different company or a different country, who owns the code? That's really kind of what the basic question is all about. And so one, you want to make sure that whatever is going on we'll just call it foreign country. So whatever's going on in foreign country is getting up to the parent, and you want to make sure that whatever the foreign country needs to do to work on it, they've got a license to do so. Now, if that company in foreign country is also selling it, they also need the rights to sell it. So maybe they buy it from the parent, okay, and then they turn around and resell it. Well, then they're going to need a license to do that. They'll need a license to with the ability to sub-license out. So that's sort of the concept there. Again, you want all the IP flow in the big picture. You want all the IP flowing up, and you want appropriate licenses going back down. The other thing you should think about, and this is kind of more on a business aspect or business side of things, is that you're going to want the branding to be the same or similar between jurisdictions. Probably, it doesn't have to be, but you're going to want to. What is branding, right? So branding includes the name of a company, potentially. It's any mark that, any mark or name that sort of designates origin, right? So it could be packaging, it could be a logo, all those things kind of fall into that trademark branding bucket of things. Although they, things like logos can also not only be a trademark, but also have some copyright protection too. With regard to that, there's sort of a cultural aspect, which is that you don't want to pick some branding that works really well in one country and is a total disaster in another country. But again, you want to make sure that all that is thought about and harmonized. There are some examples of that. This sort of one of the quintessential examples, I think, was that the Chevy back in the day developed the Chevy Nova, which here would mean sort of star, but when it was being sold in Latin American countries, Nova means no go. And so it did not do very well there, or any Spanish speaking country, I think, for that matter. So you got to kind of think ahead of those issues. All right, I'll pause there and see if we have any other questions. And if not, we'll move on to what's next. Intercompany agreements. No, okay. All right, so intercompany agreements are basically the means by which we document what we just talked about, right? How is it that the goods and, what's going on between these two companies? We've already talked about how there'll probably be a parent and there'll probably be a sub, but what is each doing for the other? That should get memorialized in at least one intercompany agreement. That will help you document for a host of reasons, or for a host of things, right? Like, where's the IP actually going, right? So that those investors, right? That's what you got to be thinking about. Those investors or those potential purchasers down the road, if there's going to be an M&A exit, they're trying to buy something, right? They're trying to buy, usually the business has a going concern. IP is a huge part of that. Obviously, making sure there's the team who can execute on the IP and execute on the business plan is another thing. But making sure that what it is they think they're buying is going to be there. You got to get that documented. You got to get that documented early in the process, and that doesn't mean that the relationship can't change and you can't redocument it. But they're going to be looking for that. So it'll identify sort of the goods and services to be provided for each one. What's going on with the IP, what's going on, and then how is money being moved around? What is the compensation for that? And those are absolutely critical. So we usually work, I work on these types of things, but we also bring in specialists, to deal with the IP and the licensing issues and a bunch of the structuring and the tax issues too. Here's yet another thing for which, I'm playing air traffic controller, right? Immigration issues, right? What is that about? Well, that's about the ability for personnel to move, to enter and leave one country and do work. And at least here in the US, we've got an alphabet soup of options. But let me talk about some of the things that are usually considered before they sort of get settled on in conjunction with an immigration attorney, which I am not. You'll be looking for each person, right? You'd be kind of thinking about what's the length of time that they need to be in the US to be doing what it is that they're going to be doing. Is it a couple days a year? Is it 6 months a year? Is it multiple years? Is it indefinite? That is, you don't know. That's one aspect. The time you have before you need the visa, right? Some of these things can get processed pretty quickly. Others take quite a lot of time to process. Whether or not the applicant is going to be interested or seeking a permanent to immigrate permanently, right? It's not just about working for a few years in the US. It's about permanent immigration. And also, really importantly, if you're trying to, and it's important for the family, of the personnel, right? Like, will a spouse need to have the right to work? Because some of these visas allow that and others don't. B1 visa. So I will kind of give you a sense for what these are, but again, please consult with an immigration attorney. I certainly would not be the person to give you immigration advice whatsoever. And there's also quite a lot of activity in that space, which I don't track. And so again, air traffic controller on this issue, this is something we work with in conjunction with our experts. So, B1 is usually for individuals who are going to be here on a short-term basis and sort of for up to 6 months. Usually doesn't take that long to get. And it depends sort of on which country you're in, but usually it doesn't take that long to get. O1As are for individuals with extraordinary ability, but it's a pretty high bar. And it usually pertains to the sciences, education, business, or athletics. And there's a bunch of proof that you have to do in order to get that. And it takes, I've heard that it takes, maybe up to 90 days to get done. H-1Bs are really not necessarily about the founders who want to come over. It's more for workers in specialty occupations. But it's possible that might work. One of the things also that works kind of well if you've got executives or managers of an established company who are kind of trying to come over here, the L1As work very well. And then there are a couple others which are on there, which are E2s, which deal with basically ability to invest your personal funds. The goal is basically trying to make sure that you can get jobs here, to promote more jobs in the US. And the EB1A is pretty much like the O1A. But I believe it allows you to immigrate to the US. again, please consult with your immigration attorney. But that is usually one of the top areas there. So one of the things that, again, that, we kind of put the tax people together and the immigration people together on this, because you want that individual to know when they're going to be subject to tax. Now, another question that we sometimes get, which I can give you a high-level answer to, is, well, if I'm going to get taxed in both jurisdictions, does that mean I'm going to pay double tax? And the answer is, like, usually, and this is frequently covered by treaty, but usually you'll get sort of an offset to the extent you've paid tax in one jurisdiction over the other. But again, you got to work with a specialist on that. So I'll pause there and see if we have any other questions. And if not, we'll just keep trucking along. If you've got a question, please use the Q&A function. Okay, so here is something that is very important, kind of depending upon where your company is coming from. Employment law may or may not be highly regulated. I work with some companies in Europe and they're like, the US is so lax. I work with other companies and they're like, you guys have so many employment laws. And then even being within the US, California is known for having a much more paternal state that is being much more hands-on and more highly regulated than many of the other states here in the US. Now, let me just pause and say, if you've got set up as a Delaware C Corp, but you're still doing business here in California, you still have employees here, you're going to be subject to California employment laws. So even if you've got that corporation, I'm using quotes, that's really the wrong way to use it. Even if you have a corporation that is a Delaware corporation or some other state, employment laws are usually governed by the state in which the employee is. So let me give you a high level sense. Here in the US, their employment laws are handled at both a federal level, that is the United States government, and then also on a state-by-state basis. Each of them have, the federal government and the state frequently have very overlapping things. So for example, wage and hour issues. That is the concept that there's minimum wage here. In California, it's $12 to $13 an hour, I think. In San Francisco, I think it's now 16. So, federal, state, and local can apply on these issues. And wage and hours go minimum wage. And then for the number of hours worked, sometimes you get overtime. There are some exceptions to that. There are exempt employees, but you got to make sure you really qualify for them. And just because you're exempt at the federal level doesn't mean you're exempt at the state issue. And this is an issue that comes up all the time. Even local companies don't get it right, but it's an area that you need to be paying attention to and thinking of. Also, the issue of contractor classification, right? This is, at least in California, a very hot topic. That is, it's very tempting to label somebody who's providing services to your company as a contractor, okay? Because if they're a contractor, then in theory, you're not responsible for withholding their state and federal tax. You are not necessarily responsible for their unemployment insurance or workers' compensation payments. And then, so, to a certain extent, it's attractive on both ends, right? Because that person who's providing services may not want to declare all that income, which is not appropriate or right. And it's also, and on the company side, you may be tempted to do that because you think that you're sort of saving on some of these things. Usually we find that that is a false economy, because what will happen is at some point that service provider may be audited or, undergo some sort of scrutiny, or they may just be upset, right? They may have gotten injured at work, or they may be upset with whatever happened at work. And, they'll turn in the company, and then the company's got a big problem because usually if they've been doing it with one, it's multiple. And so these things kind of snowball and can be quite a problem. So, at least out here in California, super hot area, lots of companies try to label service providers as contractors. But, we now have, in the fall, there was a California Supreme Court test that got codified in the legislature effective the beginning of this year. And so it's very rare that a service provider is going to be an employee of a company if they're working for you on a full-time basis. So the test involves looking at whether or not that worker has direction and control over what it is that they are doing and their tasks and the time of doing that, whether the work they are performing is outside the course of business of the company, and that worker customarily is engaged in independent provision of those services sort of elsewhere. So obviously it doesn't exclude everyone, but certainly if you've got somebody who's a full-timer, it's going to be pretty hard to make that argument. And even so, it's not a full-time, part-time distinction, because you can have part-time employees. So that's a pretty hot area. Let's see what else. So we sort of talked about some of these withholding issues, unemployment insurance, disability. Another thing is just parental leave and sick leave. All these things are handled on a federal and state and also local basis. So you need to work with your employment folks. One of the basic, if you go back, and I sort of made an analogy to an onion, like the center of the onion is just making sure that all of the right emerging growth company stuff is done from the get-go. And that involves IP assignment agreements and confidentiality agreements with everybody. And further, whether a contractor or employee, you use a different form of agreement for each of those, but it's important. One of the other things you want to think about kind of on the employment related side are just equity awards, granting of incentive stock options, and making sure you've got the right kind of equity incentive plan in place. So I'll pause there because we're going to move maybe towards the end of this discussion and see if we've got any questions. It's been a quiet group. All right, so let's talk about some pitfalls and traps and some stuff that the unprepared may not be aware of. So let's talk a little bit about sort of export control laws and CFIUS. So the concept here, and we have specialists for this who we bring in, because it is a highly regulated area with very high stakes. And it doesn't necessarily apply to everything, right? I mean, if you've got a software company, the funny thing is it'll apply to things that you don't necessarily think that it'll apply to too. But not every software company is going to be involved for it, but not every software company that you think would be involved is actually going to do that. So what's going on here are, to the extent that there are technologies that are of significant importance to the U.S. government and sort of even more specifically national security, those technologies can't be shared or require government approval before they can be shared with foreigners. That is, foreign persons, non-U.S. persons. And those come up in the export control and CFIUS. And the export control, and the hard thing also is that these can come up in items that have dual use. So if and the sort of quintessential example of this is GPS, okay? It has both a civilian use, we use it to get around the city or your town all the time, but it can also be used for Tomahawk cruise missiles to get piloted to their destination, right? So technologies that you wouldn't necessarily think of can be subject to that. I mean, sort of similarly, one of the really hot topics or areas with regard to CFIUS, which is the Committee on Foreign Investment in the United States, is TikTok, and the fact that they've accumulated quite a lot of personally identifiable information. And as a result, there's been a lot of pressure, and there's, I believe, a Chinese investor that, to divorce those folks, and they have to sell their stake in that. So I haven't been following it super closely, but I have seen the headlines. Sort of a similar thing I think happened with Grindr. And so, this comes up on a few levels. So, if you're going to be developing technology here in the US, you may need to pay attention to this depending upon what the technology is. I mean, and one of the super hot areas is AI, because that is potentially a dual use technology, right? It can simulate customer service experience, or it can, run a weapon system or do any kinds of other things. I mean, especially also like in the autonomous driving space. It comes up there. It comes up if you're going to have foreign investors in the companies, right, in that technology. So something you need to be paying attention to, and has only become sort of hotter in the last 4 years. One of the things that's also a real pitfall is if we kind of talk about that inner layer onion again, just having non-standard terms or non-standard documentation is gonna set you back if you're gonna try and do a financing or an exit. Now, it's a little hard because I'm gonna tell you non-standard terms are a problem. At the same time, I'm gonna tell you there are no standard terms. And both of those things are right. It's kind of like there is a continuum of what is considered normal, and you just want to be within that continuum. So when I say standard, I don't mean like there's only one way of doing it or even two ways of doing it, but there is a norm. And some of that will even go to, let's just say, some of that basic inside onion stuff, right? Which are the vesting agreements in place with founders or other key personnel, right? If you've got single trigger acceleration, or you've got everybody fully vested, that's going to need to change. Well, it may likely need to change before you can raise your round. I guess sort of one other pitfall as I sort of talk about vesting that we haven't talked about is another pitfall is the 83B election. So let's say you've got a founder who's come over here, they're going to stay over here indefinitely. They've gotten issued their shares. They're going to be subject to vesting. That is, although they're going to get all of their shares up front, those shares are going to have strings attached, so they need to stay there for a certain length of time. And as they stay there, each of those strings is going to get cut. And if they leave before all the strings have get cut, they get to walk away with the shares that don't have the strings on them. That's kind of my analogy for vesting. Here in the US, there's, if you receive property with a substantial risk of forfeiture, that is, if you leave, it can get taken away. You're not deemed to actually have received it until it is no longer at risk for forfeiture. And as a consequence, what that means is, although you may pay for that stock, even if it's just a nominal amount, you're not deemed to have actually received it until the strings are cut. If when you first pay for it, you pay a penny for it, let's say, but then when the string gets cut, it's worth $10 a share, then potentially you're going to have tax on $9.99. And the way to address that is the 83B election, which allows you to basically prepay the tax. I don't know why I'm using quotes. It allows you to prepay the tax, or at least declare it when you receive it. And so, if you paid fair market value for it in some nominal amount, you may not need to pay any tax up front. But the flip side is, if you've declared and you've paid for it, but then you leave, whatever you've had to pay on that tax, you walk away from. But usually we find, folks will end up doing the 83B election to avoid this issue of basically their tax vesting over time, and they basically accruing tax liabilities over time, without the cash to pay for it, which is the real problem. So with that in mind, let me just see. Let me just think about that for a second, see if there's anything else I want to add. Now, another sort of pitfall is sort of thinking that the laws here in the US and the states in which, which make up the US are going to be the same as that foreign country or that international country that you're coming from. It's different. We're in a common law jurisdiction, which is different than civil law. So, a lot of the European countries are very different. little bit more similar, I guess, in the UK in that respect. But in terms of like the regulation and regulatory scheme, you know, law to a certain extent is all just about the codification of culture and rights and norms and who owns what. And so there are different norms and customs all throughout the country, all throughout the world. And so everything gets codified differently. Additionally, here in the US, each state is its own sovereign. And so for many of these, as we've sort of talked about tonight, many of these issues, the state will have its own laws that are covering some of these things. Some of it's preempted by federal law, but a lot of it, the employment, all that kinds of stuff, a bunch of tax issues, each state's gonna have its own. Just getting ahead of the tax and accounting issues, making sure that you've got the right folks who can advise you on that, I think is pretty crucial. And then, you know, making sure you've just got the right team in place to deal with these issues. So as I've sort of said at the outset, this was a very interesting presentation to give tonight because there are like 6 topics that are highly regulated that have their own sets of specialists. My usual role in these types of situations, and I love them because I get to work with a lot of fantastic specialists, is to play air traffic controller and make sure that we've hit these big picture issues. We hit the issue with regard to structure, with regard to IP, with regard to the employment issues, with regard to the integration issues, if I haven't said it already, tax, and make sure that we've sort of weaved all this stuff together so you can be successful and you can focus on growing your business. And when it comes to raising capital, that's also my area. And I like to focus on that as well. So with that, you know, we are almost out of time, but I'm going to call it. I'm going to say, and I'm going to pivot to answer any questions that you have, and I'll give you a couple of moments to ask them. And you know, if you don't have any questions, then we'll sign off. So, all right. Are there any questions? If so, my preference is if you use the Q&A function. And if not, you can still use the chat function because I'm looking at it. Oh, here we go. All right, so the question is, how can I explain a little bit more about right advisor versus wrong advisor? How do you recommend us to find a good advisor? Is that me? Okay, I'll start with a softball. Yeah, so I would be the right advisor for certain issues for certain companies, absolutely. So if you are intending to be venture backed and you're coming in from abroad, potentially it is a fit. I would not be the only advisor for that. So, you know, as I mentioned before, my firm's got 900 attorneys and 20, 25 offices across the US. And we've got folks with IP experience, with tax experience, with employment and immigration. So we can answer and address a lot of these needs. But really what you're going to want to do is you're going to want to, you know, get connected with a team, okay, whether it's all in-house at one place or a couple of different places where those practitioners are in the mix every day and dealing with these issues every day. So even if they're a tax person, they'll kind of be heads up enough to to recognize an IP issue and say, well, you know, I've worked with so-and-so on this type of IP issue before. Let's get them involved. So I think that's a great way. I mean, certainly if you've got an interest in a specific advisor, I'd be happy to chat with you later or send an email. You know, if it's not my area of expertise or not something that my firm does, or even if it is and you're looking for another name, happy to be helpful there. My email address is jgordon@polsinelli.com. It's actually, you know, appended to my name on the Zoom screen here, so you can be able to see that. And then I have it at the beginning of the slideshow as well. We can and will make the slides available to people afterwards, and we will also have a recording of this up in the next couple of days or so. All right. I think at that, I'm going to call it. So I want to thank everyone for attending this evening. I want to thank Rob Lau for and Idea to IPO for organizing tonight's event. I hope that you found it interesting and helpful. My name is Jason Putnam Gordon. I'm a corporate and securities attorney focusing on startups and venture capital at Polsinelli LLP. Thank you very much and have a good evening. And we'll cut this part out.